Squeeze human nature into the straitjacket of criminal justice and crime will appear, by Karl Kraus. These are some of the topics that we'll go more in depth to, and they're going to be criminal law, the criminal code, history of the criminal code, and provincial jurisdiction. So what exactly is criminal law? Criminal law is a category of public law which punishes people for crimes they commit. This can range from theft all the way up to murder. Criminal laws are usually made by the federal government, but some laws can also be made by the provincial or municipal level governments. Under the eyes of the criminal justice system, everyone is innocent until proven guilty, and therefore a crown to sentence someone, they must prove beyond a reasonable doubt, which means they have to be 95% sure the person committed a crime and they must provide the evidence to support it. In the Criminal Code of Canada, there are three categories of criminal offences: summary, indictable, and hybrid offences. Summary offences, the least type of serious crimes, include disorderly conduct, trespassing, public nudity, and etc. These crimes usually carry a lighter sentence as well. Indictable offenses are the more serious types of crimes. These include murder, terrorism, robbery, and etc. These crimes generally carry a longer sentence as well. Hybrid offenses is decided by the Crown if they want to charge a person with a summary or indictable offense. An example of a crime would be possession of cocaine. The Criminal Code of Canada was first established in 1892. It defines acts that may be considered a crime, and it also provides the appropriate degree of punishment that should go along with the act. The code is updated yearly to keep up with technological advances and changes in society. With the technological advances, there are new cybercrimes being introduced, like hacking into government hardware. The provincial level government control the administration of justice, which means that they must build and maintain courthouses as well as appoint judges and court clerks to work in the courts. The court pictured on the left is the Provincial Criminal Court, which serves York, Peel, and Durham region, and the picture on the right is the Ontario Provincial Court of Appeal located in Toronto.
The element of a crime. Actus rea, the guilty act. Mens rea is the guilty mind. These two factors are needed for a person to be found guilty of a crime. For example, if you're smuggling drugs across the border and you didn't know it was illegal, in this case, you have the actus rea but not the mens rea. Now, if you're smuggling drugs across the border and you knew it was illegal, then you have the actus rea and the mens rea. Therefore, you are guilty of the crime. Involvement of a crime. In a crime, we have the perpetrator, aiding, abetting, counseling, accessory after the fact, and party to common intention. The perpetrator. The perpetrator is the person who actually commits the criminal offense. For example, if a robber walks into a bank, pointing a gun at the teller, collects the cash, and then escapes, that person is the perpetrator. Aiding. Now, what is aiding? Well, aiding means to help a perpetrator commit a crime. For example, let's say a pharmacy clerk gave her boyfriend Bob the store key. He uses the store key to break in and steal prescription drugs. Lisa aids Bob into breaking the law. Abetting. Abetting is when you are encouraging the perpetrator of a crime without actually providing physical assistance. Now let's say Bill is assaulting Raj in a school parking lot. Carlos is encouraging Bill to hit Raj repeatedly. Carlos didn't touch Raj, but the police later on arrested him for abetting an assault. Counseling is a crime that involves advising, recommending, or persuading another person to commit a criminal offense. Accessory after the fact is when someone who knowingly receives comfort or assists a perpetrator in escaping from the police. Now, let's say your friend escaped from prison and you let them stay with you, giving them all the medical help they need, the food, and a place to stay. Once the police track him down, they will be arresting you too for helping him stay with you, and now you will be charged with accessory after the fact. Participants in a criminal offense can be charged with all these additional crimes, even though they were not directly involved in them. If 6 people hijacked a security truck and one of them kills the driver, all 6 can be charged with murder. This is called party to common intention. How does this apply to the Canadian Charter of Rights and Freedom? In Section 11, any person charged with an offense has the right, subsection D, to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. Subsection I, if found guilty of the offense and if the punishment for the offense has been varied between the time of the commission and the time of sentencing to the benefit of the lesser punishment. Questions. If Carlos is encouraging Bill to hit Raj repeatedly, what type of offense is Carlos committing? A. Counseling. B. Aiding. C. Abetting. Question number 2. When was the criminal code established? A. 1892. B. 1890. C. 1893. I hope you enjoyed our presentation on the nature of crime by Zaid, which is me,